2019 following a lawsuit that was in your court and lasted a couple of years. And we settled that lawsuit with a written settlement agreement under which the Dynesic defendants disclaimed all right, title, and interest to a specific formula for a product called Art Resin that had been developed by Whitney Wheaton, one of the indirect owners of Resid Ventures. And in addition to that particular signed written agreement, there is also implicated in this lawsuit a signed written confidentiality order, confidentiality agreement, and protective order that Your Honor entered in that lawsuit, prior lawsuit, in December of 2017. So our lawsuit alleges that the Dynesic defendants have breached both that confidentiality agreement and the settlement agreement by having and using the formula that Mr. Wheaton developed and that is used by Resid Ventures to sell its product called Art Resin, and that the Dynesic defendants specifically disclaimed. The subject of this morning's hearing is a third agreement that we say the Dynesic defendants are now dishonoring, which is called it was a Rule 11 agreement that we entered into last year, and that attaches and incorporates what's called an agreed protocol for forensic inspection. The Dynesic defendants denied early and often that they had Mr. Wheaton's formula and that they were using it. By agreement with Mr. Wiegand.
Yana, why don't you come up here so you go ahead. So you can
by agreement with the defendants, sorry, Your Honor, let me back up just a minute. Resid Ventures retained an expert called Digital Discovery, Inc. They are our retained expert. Rather than incur the expense of another expert, we agreed to pay for a forensic inspection of devices and accounts belonging to the Dynesic defendants. So we have a written agreement that is attached to the motion, which I'm going to ask Your Honor to refer to in a minute, that governs a procedure by which our expert Digital Discovery came to the premises of the defendants and created images of two desktops, one belonging to Mr. Phillips and one belonging to defendant Novicki, that captured what was on their desktops. We also, by agreement, imaged cell phones. And the specific subject of today's motion is that the Dynesic defendants were also required by this agreement to provide access to Digital Discovery to the Outlook and Microsoft 365 servers that were used by Dynesic, Phillips, Novicki, and co-defendant XMed. XMed and Dynesic, as Your Honor may remember, office together at the same premises. So we have been proceeding for the last year, and it has taken some time because of the way the protocol was set up. We have been proceeding for the last year to capture, to analyze the data that were on those images. And under the protocol, the defendants have two opportunities before we plaintiff ever get to see it. That is to look at the data, look at the information, look at the emails and attachments to determine whether there are privileges to be asserted, because these are emails, but among the defendants and among third parties, to determine whether there are any objections to our plaintiff seeing these documents, just as you would do in regular discovery in the lawsuit. And they have an opportunity first to redact even a list of the documents if the list of documents by its description would implicate a privilege. Once that was done by Mr. Wiegand, then the documents that he would then be identified, and Mr. Wiegand would have a second bite at actually looking at the documents to raise any objections to the emails or attachments that had been determined by Digital Discovery to fit into the category required by the protocol. And Your Honor will see when you look at the protocol that there is a list of search terms. Now, let me segue just a minute. One of the early items that we alleged that the plaintiff had done, I'm sorry, that the defendants had done, was to improperly retain the confidential PST files that had been produced in discovery in the prior lawsuit under the protective order, confidentiality agreement and protective order. And we believe that they had it. They denied that they had it. And the initial purpose of this agreed protocol was to have digital discovery determine whether the defendants had in fact improperly retained on their computers this PST file. And the PST file is important because it contained emails and attachments that disclose the formula that Mr. Wheaton developed. So after denial that they had it, the digital discovery determined after they imaged Scott Phillips' desktop that he, Mr. Phillips, in fact, had those PST files, including the ability to access all of our formulas on his desktop, and had them there since February of 2018. So that event, which occurred because of this forensic inspection, determined that they had in fact violated the first agreement, Your Honor's confidentiality agreement and protective order. They had the PST files with the formulas on Mr. Phillips' desktop. Secondarily, after we analyzed the data, the other data that, secondly, there is attached to the agreed protocol a list of search terms, formula, specific ingredients, specific companies, specific people, because we wanted to determine whether the Dynesic defendants had, in fact, communicated with people, shared with each other the formula, and so forth. That has been ongoing for the last year. And we believe we have determined conclusive evidence that they have both have the formula and have been using it. Now, what we have not been able to pin down sufficiently is whether or not these defendants have communicated with third parties outside of the defendants in the lawsuit. One more as an aside. We discovered that Mr. Novicki had set up this company called PACT Enterprise.
Mr. Reynolds, what are you asking today? You've given me a lot of background. You guys have canceled a lot of hearings lately. And so I've kind of.
Yes, Your Honor.
What am I deciding today?
Right this minute, we'd like you to turn to the first page of Exhibit A to the protocol, which is Exhibit A to our motion.
Okay.
And Your Honor, I'm sorry, I'm suffering from a broken arm and I'm not unable to work the share screen.
Okay.
Even if I were capable of doing it, which I'm not sure I would be.
Okay, let me see. It's sorry to hear that. So it's Exhibit A. Okay, I see Exhibit A is agreed protocol for forensic inspection of electronic media recording devices. Okay, and then what is?
Yes, Your Honor. Now, paragraph number 1 says digital discovery shall have access to the following devices, and you'll see bullet points.
Right.
And if you go down to the 6th bullet point, P2, which is the defendant, digital discovery shall have access to P2's cloud-based storage systems.
Okay.
If you look down at paragraph 2, it says that simultaneously with this delivery, P2, which is the defendants, shall provide all login and password information associated with the devices and accounts to the inspector.
Okay. So what are you asking me to do?
Mr. Wiegand or the defendants have refused to provide what we call administrative access to the Outlook 365.
Got it. Mr. Wiegand, what's your response?
In the cloud. And we asked you to enforce this agreement and require them to do that.
What's your response, Mr. Wiegand? You're muted, Mr. Wiegand. You're muted.
Before I respond, Your Honor, is Mr. Reynolds now limiting, there's much more in this motion. Is he now limiting the request he's seeking to just the passwords?
Your Honor, our motion was originally filed with three objects. The reason we've been so long in setting it is that Mr. Wiggin and I actually reached agreement on point 1 of the motion. This access to the cloud is point 2 of the motion, and point 3 of the motion, which won't take long to argue, is basically there are about 20 documents that Mr. Wiggin has withheld on the ground of relevance, and we are asking Your Honor to review those documents in camera and make a ruling on his objections. But Your Honor doesn't have to do that today. He just has to order Mr. Wiggin to provide those documents to you in camera. But the main thing that we need Mr. Wiggin to do in respect of this part of the motion, ask Your Honor to do, is to just say, give us access. And by us, I mean digital discovery. We will still not have access. We, the plaintiff, will still not have access to the cloud information and data until digital discovery then runs the search terms, provides the reports, gives Mr. Wiggin an opportunity to object, and so forth. It's a process, but we're asking Your Honor to enforce the agreement and require Mr. Wiggin to honor this very clear obligation to provide access to digital discovery.
Response?
So Mr. Reynolds is still asking for us to be required to submit those documents identified in camera?
That's what he said, yes.
Okay. Your Honor, may I share my screen with you?
I need to unshare this. It's just not what you need here on the screen?
It's not.
Okay. Go ahead.
Okay. Host disabled participant screen sharing.
Oh, let me do that. Let me change it real quick. There you go.
Okay. Okay, can you see a case in Ray Shipman on your screen now?
No, but it's a lovely background of some mountainside that is apparently on your computer. Very pretty screen share. It's great. What is that background? Wallpaper.
Wallpaper.
Isn't that pretty wallpaper though?
It comes up automatically every day. Microsoft changes the wallpaper.
This is a really pretty one.
All right, let me see.
I don't know there's anything I can do. There we go. Okay.
Okay, now can you see it?
Yeah.
Okay. This is a 2018 Supreme Court case called In Ray Shipman. And it says that as a threshold to granting access to electronic devices, the requesting party must show that the responding party has somehow defaulted in its obligation to search its records and produce the requested data. We cannot rely on mere skepticism or bare allegations that the responding party has failed to comply with its discovery duties. And at its core, Your Honor, the plaintiff's request that we submit documents to you in camera for your review is basically the plaintiff saying, we don't trust Bob Wiegand gave us everything that we're entitled to.
Let's deal with the first issue. That's, I think, the second issue. Let's deal with the first issue.
They're intertwined, Your Honor, respectfully. And I have a lead up to that issue regarding the passwords, if I may. Okay. So what we have essentially is that the plaintiff says, I don't trust Bob Wiegand gave me everything. That's despite the fact that in the normal course, the plaintiff would have sent us a request for production. We would have responded and produced documents or made objections. They would have had no access to our electronic devices. We voluntarily did that outside of discovery, pursuant to a separate contract. The Rule 11 agreement itself This is what was filed. That forensic agreed protocol is not the Rule 11 agreement, Your Honor, and is not enforceable by this court as a Rule 11 agreement. This that you see on the screen is the Rule 11 agreement. And it says, separately, we have entered into this agreed protocol, which has not been filed with the court to be enforceable. And then at the bottom of the Rule 11, it says that we consented, my clients consented to the forensic inspection by the plaintiff pursuant to the protocol in exchange for the agreement that's memorialized herein. So the agreement, the Rule 11 agreement is right here on the screen. That's the agreement. That's the only one that's been filed with the court that can be enforceable as a Rule 11 agreement. This agreed protocol is a contract between ourselves and Digital Discovery and the plaintiff, that if the plaintiff alleges a breach of that contract, he can't enforce it via just a motion, not even a motion for summary judgment. He's trying to enforce a contract via a motion, not a Rule 11, a contract. And Your Honor, I respectfully suggest that this non-filed contract is not a Rule 11 and is not enforceable as such, and that this document that's on the screen, the actual Rule 11 agreement, that provides for what plaintiff will do in exchange for us entering into this separate contract is what is enforceable. And we did our part. We entered into the contract and they did their part. They provided the document to me. Now, we, the defendants, dispute Mr. Reynolds' characterization and interpretation of that contract, the agreed protocol. And we believe their remedy is to sue us for breach of contract. Now, this is not a traditional discovery dispute. There was no request for production. There was no response. There was just a list of terms to search on some electronic devices. And that was done. Because it was just a search of terms, it returned a lot of junk. I have on the screen now the first page of the protocol. And despite my contention that this is not something that can be enforced as a Rule 11, I'm prepared to respond to the contentions because I believe Your Honor will see through this for what it is. And that is, as the Supreme Court put it, mere skepticism and a bare allegation that they just don't trust that we gave them everything. So my client is an epoxy company that sells epoxy products that include ingredients, and they have inventory of raw materials and product, and they mix things, and the word form. So you can imagine with these search terms, which we don't object to, it returned a lot of junk. 70-something thousand different communications that had tens of thousands of attachments constituting hundreds of thousands of pages. Okay, so the plaintiff and the defendants worked together to narrow down the scope of what was returned from these searches. We limited the dates. We changed some of the words, etc. And we got it down to about 7,500 emails with some of them had attachments, but and multi-page attachments. So we're still talking about tens of thousands of pages. And the report that was generated was prepared by Digital Discovery. This agreement was entered on February 10th. It provided for the search and then 10 days to look at it and make objections, 10 days to winnow it down. But even with the winnowing down, on March 23rd, I sent Mr. Reynolds the email search report prepared by Digital Discovery, and the Chip refers to Chip Coons at Digital Discovery. And this is an example. This is the first page of that report. Now, if this had been opened in Excel, it would have had along the left here the numbers that you see in the motion, 1392, 1393, etc. So the contention on page 8 of the motion that the absence of the detail required in a withholding log makes it impossible to assess these objections. The plaintiff is pretending like he doesn't have this report that shows the date of the email, who the subject matter, who it's from, who it's to, whether it was copied or blind copied to anybody, which terms were found in that email, whether it had an attachment the names of the attachments and where it was found on the computer. So these objections that you see in the motion have to be taken in connection with this report. So to say that we didn't give them enough information is not accurate. We have these objections, but they relate to this report that gives them all the
So
information.
let me make sure I understand this. So this report that you provided that's on the screen, these are documents you produced or you withheld?
This is a list of once we've narrowed it down from 75,000 to 7,500. This is the report of the 7,500.
And these are documents you produced or withheld?
No, these are the document. This is the list from which Mr. Reynolds was allowed to choose. So he went through this list and he said, I want number 1, I want number 10, I want number 15, etc.
Okay.
All right. And so from the list that Mr. Reynolds then gave me, I looked at the actual document, not just the report, and I said, I have these objections. And you can see on pages 6 and 7, there are about 20 documents that he asked for that I said.
So
no.
why wouldn't I review those? I mean, I just don't get why I wouldn't. If it's
Okay, because this is not a discovery dispute under the rules of civil procedure. Number one, this is outside of the rules of, this is an agreement outside of the rules of civil procedure. This is a contract between the parties. There is no mechanism by which the plaintiff can challenge our objection to producing a document. If Mr. Reynolds wanted to, he could now send, based on this report, he could send me a request for production that says emails between, looking at this first line, emails between Mike McCall and Scott Phillips regarding 2005 wholesaler customer list. He could send that request. And if I had an objection, he could submit it to Your Honor for review. That's not what he's done. Instead, he's tried to short circuit it, and he's trying to enforce a contract via motion rather than suing us for breach of contract and filing a motion for summary judgment. Now,
let me ask this, because this is the way you've done this is a little unusual. So there was a Rule 11 agreement with an agreed protocol. Did I sign the agreed protocol, or was it just something between the parties?
Just between the parties, and it wasn't filed with the court. It's contained in his motion, but it wasn't filed as a Rule 11 agreement. The Rule 11 agreement is the one that I showed you. This is what was filed.
So this is what I'm confused about. Rule 11 agreement, and then it had attached.
Nope.
It just, so the Rule 11.
It's just Rule 11, and it says, we entered into this deal, and in exchange for that, we've made this agreement. The agreement is memorialized in this document, and it doesn't say any of the things that are contained in the agreed protocol. The agreed protocol is not incorporated into it. It doesn't incorporate that agreed protocol. But you'll see from what I mean by this is just an exercise in the plaintiff doesn't trust us. Remember what Mr. Reynolds said, that this is what they have left undone is whether we communicated their formula to anyone else. Well, in their motion, the first two documents that they say they want to look at are 1392 and 1393. 1392 is an email, 1393 has an attachment. This, what you're seeing on the screen, is the attachment. My client's main product is called Pan Seal. It seals air conditioner drip pans, right? This has nothing to do with art resin or epoxy for art projects. This is an alphabetical list, and I've redacted it here, but it's an alphabetical list of HVAC suppliers in different states, starting with Alabama, Arizona, then Arkansas, etc., to whom my client may try to sell Pan Seal. He has that information in the chart. And then I also gave him an explanation that says it is a list of potential clients for Dynetics products, and this is right in their motion, and thus is also a confidential trade secret. This document is a compiled list of potential customers, which falls squarely within 134A definition of a trade secret, confidential trade secret. And I don't want to give it to him. And Mr. Reynolds says, Well, I just don't trust that's what it is. I'd like the judge to look at it. The next one on their list is 1722. This is an Excel spreadsheet. It's an attachment to an email. It was created back in 2006. It's been regularly updated by Mr. Phillips, one of the defendants, every month. Here's the very first page of it. It started out as a crude list of Mr. Reynolds' personal monthly payments, him and his wife. And then it had a list of the amount due and whether it was paid or not. Okay, his direct TV bill, his water bill, his insurance. Over time, I'm going to go to the last page. It evolved and got more sophisticated and includes his Best Buy bill, his energy, but it also included the amount that's due, whether it was paid, the balance of it, and it includes account passwords, usernames, and account numbers. And you'll see in my objection, it's an Excel spreadsheet containing contact information, usernames, passwords, and notes about Scott Phillips and his wife Lana's accounts, GM, Best Buy, Lowe's, etc., and is thus confidential. This has nothing to do with whether we provided that formula to anybody else. Mr. Reynolds has the chart that shows it. He has my explanation and objection that shows this, and he just doesn't trust me. I provided both of these documents to Mr. Reynolds in the last few days in a redacted form to show him this is not the Android you're looking for. But his clients don't trust us. The last document is 1705. I have several examples, but 1705, I put this is a strategic planning document of my client Dynesit. Jim Chafin, one of the owners, is dying of pancreatic cancer.
So Regan, are you okay? I'm sorry to hear that.
He is a friend of mine. This document is between Scott Phillips and Jim about what to do when he dies. You'll see how to handle Jill and Lana. Jill is Jim's wife. Lana is Scott's wife. We need to agree with a fair way to handle this in the well, you know. And what the well, you know, is when you die. He has pancreatic cancer. He's going to die. Mr. Reynolds seems to think that his clients are entitled to see this. Why? This has nothing to do with whether my client communicated his client's formula to some third parties. What do we do about his salary since he's not working? What can we do? What can Jim do while he's being treated? Can you come up with new ideas? You can't come into the office. Since you can't do the books anymore, I need to hire Anna to assist me with QuickBooks. This is not the kind of thing that Mr. Reynolds' client is entitled to see, no matter how curious he is, no matter how much he or his clients don't trust me or my clients. I've given him all this information. He has the chart, and this is just an exercise in morbid curiosity because they don't trust us. We've complied with the forensic examination. We made the objections. I've gone above and beyond to show him that these documents are not anything that he's entitled to look at, or quite frankly, should even want to look at. They just don't trust us. And under Shipman, mere skepticism or bare allegations that we, the responding party, have failed to comply with our discovery duties is not enough. Mr. Reynolds has not even made an argument or produced one word of testimony or other documentary evidence that we did not comply with our obligations to give him responsive documents.
So there's a procedural issue here, and then there's the substantive issues. I see the procedural issue is the motion that Mr. Reynolds brought the correct mechanism to try to pursue this dispute, I guess. And I'm trying to get my mind around exactly how this all works. So this was a Rule 11 agreement that was in a previous lawsuit that was filed, and it had this agreed protocol attached or not attached, referenced in it. No?
No,
This
no, Your
Rule
Honor.
11 agreement is in
No,
this
Your Honor,
clause.
this Rule 11 agreement is entered in this case.
This
Right.
lawsuit, okay, because you were
This
talking about
lawsuit,
another lawsuit, okay?
and it's, and my answer to the procedural argument is, we refer to the precise agreement that is the subject of this Rule 11 agreement. We did not have to attach that agreement to the Rule 11 agreement to make it enforceable as part of the Rule 11 agreement. If Your Honor looks at the yellow highlight that is right in front of you, defendants have consented to the forensic inspection pursuant to the protocol. And it is the protocol that we are seeking to enforce today. And despite all of Mr. Wiegand's arguments about the second part of the motion with respect to specific documents, Mr. Wiegand has not yet addressed how come he does not have to honor the specific obligation in the protocol to give digital discovery access to the cloud. And that's the part we started out discussing. And Mr. Wiegand has gone far afield into matters that are not even before the court. We did, in fact, talk to Mr. Wiegand. We've spent a lot of time talking this week, and the specific documents that he just has put in front of Your Honor are documents that I agreed was that we would not be entitled to. It doesn't, but Your Honor's inspection in camera of 20 or so documents is the second part of the motion. We still urge that Your Honor does that, but Your Honor would reach the same conclusion that Mr. Wiegand and I agreed, that private conversations between Mr. Phillips and his, or a list of Mr. Phillips' personal obligations to Best Buy and others, that we're not entitled to that, and I don't want it. But until Mr. Wiegand first just put this up on the screen, we couldn't tell from his objections when he just said they are irrelevant. We couldn't just accept that without further explanation. When he gave it to me, I said, okay, that's fine. But that did not resolve all of them, okay? But back to the main point, Judge, where I started, this, to Your Honor, we're just asking you to enforce this Rule 11 agreement and make Mr. Wiegand honor the agreed protocol and give us, or give digital discovery access to the cloud. And if we have later arguments about what the cloud image and analysis shows, we will be back to take that up with Your Honor if we can't reach agreement on it. But the cloud is just the last piece of a forensic protocol that Mr. Wiegand has and we have been operating under for the last year. And it's the last piece, and until we see their cloud data, which is not going to be on the desktop specific image, it's the specific image is like a day in the life of, or a wheel on an automobile. The cloud contains the entire automobile with metadata, and we will be able to determine whether our trade secret has been sent via email by Mr. Novicki or Mr. Phillips out to somebody else. That's the last stage of this protocol. But our Rule 11 agreement does in fact incorporate that protocol, and we think we have the right procedural motion for Your Honor to require Mr. Wiegand to honor it and allow that access.
Your Honor, that's why I asked at the very beginning of my presentation, is plaintiffs still contending that they want us to submit all these documents to Your Honor for in-camera review? And while it may only be about 20 documents, it's a few hundred pages. That one document with the list of customers by itself is 40 or 50 pages. There's a page or two for each state. So, you know, it may even be 100 pages. That's why I asked. He still wants Mr. Phillips's credit card bills and mortgage information to be submitted for review. And
Your Honor, I don't.
Based on, and I gave Mr. Reynolds that credit card stuff redacted. I gave it to him before the hearing today. That document that showed that one of the other ones, I gave it to him and said in a redacted form, look, you don't want this stuff. And then I asked today and he says, yeah, we're still wanting all these documents submitted for in-camera review. Regarding the password, I refer back to my previous contention that this is not an enforceable Rule 11 agreement. This Rule 11 agreement you have on the page, it was filed February 18th of 2021. It does not incorporate the forensic protocol. That forensic protocol has not been filed as a Rule 11 agreement. In fact, it's not a Rule 11 agreement, it's a contract. And it's not enforceable in that way. That's number one. Number two, even if you look at the forensic protocol, on page 1 of the protocol, paragraph 2, it says simultaneously with this delivery, P2 shall provide all login and password information associated with the device and accounts. Devices have been imaged, phones and computers. Devices and accounts is defined as computer, mobile devices, tablets, and electronic devices that are used to store, access and store the plaintiff's material. Okay, it's devices. They have the devices. The cloud stuff is not mentioned in the "we shall provide all login and password information associated with the devices and accounts." Is not included. That's number one. Number two, even if you, I think that's absolutely correct. But belts and suspenders, even if you disagree with me, it says simultaneously with this delivery. Mr. Reynolds' clients found out how much Digital Discovery was going to charge for all this. And Mr. Reynolds has shared with me that they've spent like $150,000 with Digital Discovery so far. And when they found that out, they unilaterally determined that they were going to limit their search to the phones and computers of Scott Phillips and Brandon Novicki. They made that choice. Our obligation was to provide information to them back in February. They passed on that opportunity, and now they're trying to come back and say, oh, well, we've changed our mind. I think they're reading it wrong, but even if they weren't reading it wrong, that opportunity has sailed. We're not required over a year later to say, oh, well, you've changed your mind. Well, the landscape has changed too. The idea behind this was, hey, let's get this over. Let's prove to them we haven't done anything wrong, which I think we've done. I disagree with the contention that we have anything that we're not supposed to have on the company's computers. But devices and accounts is defined in the bullet point above it for it to be computers, mobile devices, tablets, and other electronic devices that we use to access or store their materials. They would have to first show that the cloud is something like a computer, mobile device, or tablet, which is not, number one. Number two, they would have to demonstrate first that it contains their information. The cloud contains their information in order for it to come within the definition of accounts and devices. They have no information. They have presented no evidence. They've not called a witness to testify that our cloud includes their information.
Yep.
This has gotten so far beyond the scope of what anybody intended, and so far beyond the scope of what is necessary for what Mr. Reynolds claims is simply an effort to determine whether they have communicated the formulas to anyone else. They imaged our computers, which included all of our emails, which sync to the cloud. In other words, every time I open Outlook 365 on my computer, it syncs with wherever. That's how I'm able to access the same emails from my phone or from my house. They're all synced everywhere. They captured that from our computer. And they're saying, well, what if there's one in the cloud that wasn't on the computer? Well, first of all, I think that's absurd. But it doesn't matter because it doesn't fall within the scope of what the parties agreed to. And so,
guys, I think we've kind of beat this dead horse. Right. I'm going to go ahead and, I tend to agree with Mr. Wiegand that this is not the correct procedural mechanism for this. I've looked, while you guys were talking, I was kind of looking at some case law with Rule 11 agreements, and it's typically, I do have probably a duty to enforce it, but it's in the form of a breach of contract. And so
right.
I just kind of wonder if it isn't, forcing him to go through all of those procedures, I mean, I think you could do requests for productions, you could sue under the Rule 11 agreement. I'm not sure about this whole issue about whether or not the agreed protocol is part of the Rule 11. It seems like it is. I tend to think I'm willing to go out on that limb that it is part of the Rule 11 agreement, but I don't typically, for example, if you have a settlement agreement that settles the entire case and then it's breached, you'd have to amend your petition and sue for breach of contract. I would tend to think that's the mechanism here. Mr. Wiegand, I would point out to your clients that if he sues for breach of contract for this and he wins, he would get attorney's fees for that. That may not be in your best interest. And so at this point, I'm going to deny the motion because I don't think it's the right procedural mechanism, but I would strongly encourage you guys try to work this out. I will say as to the substance, if I was able to get to the substance, I don't find your arguments very persuasive, Mr. Wiegand. I do think you should produce the 20 documents and let me review them. And I understand your argument about the cloud. It's automatically synced, but you know, I think we need to, I don't think it's unreasonable to go through that last step of the protocol, especially since it's part of the protocol. So get me an order on that, Mr. Wiegand. Thank you so much. Make sure the order says that this was heard on March 25th, 2022. And give me a copy of that order as soon as you can.
I will do it today, Your Honor. And
Your Honor, just for
Reynolds and
clarification,
I have worked together very well despite our spirited discussion here today. We've worked together very well, and I think we'll be able to reach a resolution on this. I think that the Mr. Reynolds mentioned that he had a broken arm. He's been out for a while, and that delayed our opportunity to work together to resolve this. And so I feel certain that we will be able to reach an agreement without requiring Your Honor to have to look at several hundred pages of documents.
That would be great.
Your Honor, may I just ask for clarification? Is the order going to recite that Mr. Wiegand will provide the documents to Your Honor in camera for review?
No, the motion is denied. I'm telling you, that's what I think should eventually happen, but I don't think this is the correct procedural mechanism to do this. I mean, a motion to enforce, I just don't think it's the right mechanism. And so you would need to refile this or do it as a request for production or something. But this mechanism isn't the right mechanism. So the motion is denied. All right, guys. Thank you so much.
Necessary. We will work it out.
I hope so. All right. We have our next hearing, which is
Judge.
Tony, are you ready? Let's go on the record on BC 192714, Frierson versus Hogue. Counsel, make your appearances.
Anna French on behalf of plaintiff.
Corinne Monroe for defendant.
All right, this is a motion for new trial.
Yes, Your Honor.
All right, I remember this case. I was kind of surprised with the judgment as well. You may proceed.
Okay, so I mean, the short version of it, Your Honor, is that trial was conducted on March 1st of 2022. I mean, both parties were saying that, you know, they were in the right and that the other party was in the wrong, which is pretty standard, pointing the finger at the other person. Plaintiff did produce an independent witness who, you know, was able to articulate that the defendant ran the red light and, you know, was able to produce, you know, affidavits of medical bills and records and was able to articulate all of that. And all the defendant did was, you know, say, well, you know, I didn't do it. I didn't run the red light. Actually, it was somebody else. So, yes.
Go ahead.
Okay. And so, I mean, when it came down to it, the jury returned a verdict placing, you know, 50% negligence on both the plaintiff and the defendant and did not award any damages.
And so
yes,
I don't have a problem with the 50-50. That, I mean, I think the jury could have done that. I think there's a reasonable, what concerns me is that I've seen this a couple times recently where juries have because there's a liability dispute, they then don't award any damages. I had that happen in trial yesterday as well, which I'm kind of concerned about. And so that's the focus I have, is not the fact that it's 50-50. I think that's not unreasonable. It's what evidence was that there was no damages in this case. And I guess that's really for Ms. Monroe to answer.
My turn.
Yeah.
Okay, so first of all, I understand that Miss French was not present at the trial. So she's kind of mischaracterizing what happened at the trial. And again, I'm not fussing at her. I know she just wasn't there, right? So first of all, this is not a red light dispute. And Miss French's motion does not mention the award of damages, as does not mention it. So that's not an issue here today. Okay. You know, the jury returned a verdict of 50-50, and the independent witness just simply wasn't credible. If Your Honor remembers, the witness's testimony as to how the accident happened contradicted both the plaintiff and the defendant's version of how the accident happened. In my response,
I agree with that. I mean, I don't, not that I agree with that, but I think that that's not my concern. Is what evidence was there that there was no damages in this case? Let's say the jury is correct, it's 50-50. You know, I think that's perfectly within. But what evidence is there was no damages? This was always a liability dispute. If they'd come in with 100% liability on the defendant or on the plaintiff, or 51%, I would have said, I can see that. I think that's totally, I agree with you on, but what evidence was there that that's not what they did? They said 50-50, plaintiffs should be able to recover their damages. What evidence was that there were no damages in this case? That's really what I'm concerned with.
so the jury's award of 0 damages indicated that the jury did not feel that this accident caused her damages. The causation is, which is not a part of this motion, by the way. Causation is always in the purview of the jury, right? So I don't have to controvert the meds. The jury is allowed to award any amount of money that they wish, as far as how much the medical bills are or any pain and suffering. There is no law that says that just because medical bills are uncontroverted that they are automatically awarded. So you can't disturb a jury verdict when they heard all of the evidence. There was no objection as to the witnesses. There was no, the award of 0 damages simply means that the jury did not find the plaintiffs, they did not meet their burden of proof that this accident is what caused her damages. I don't have to controvert anything. I don't have to provide alternative evidence that there were no damages in this accident. That is not my burden of proof.
Response?
So, I do understand that that's not, the defendant's burden of proof. However, with the 50-50 verdict, they're not actually finding really one way or the other. They're just saying, we're finding that both of them were, that's a percentage of negligence attributable to each person. And so, once you move beyond that, they can still award the damages. And, the fact that they didn't is doesn't make any sense based on the fact that, yes, in, defendant's motion, counsel mentions that, that plaintiff was, now I'm completely losing my train of thought, but that she was impeached several times during her testimony regarding the issue of pain and suffering and impairment. That has nothing to do with her past medical damages. That's there. It doesn't make any, I know that that's not a legal standard or anything, but it's unheard of that,
But Amanda, it's not unheard of. It happened yesterday in another trial. This isn't the first time it's happened in a trial with me, and it's probably not the first time it's happened to you. The point is, the jury is the sole arbiter of the credible evidence. The jury did not find your client to be credible, and so they awarded 0 damages.
Directed at me, Ms. Monroe, not directed at her.
Right, exactly.
The fact that the jury didn't award any damages doesn't mean that they didn't find the plaintiff credible. I mean, they could have found no one credible, or they could have found everyone credible, and there was something else. I mean, we didn't poll the jury, or I assume that the jury wasn't polled to say, well, did you think anyone was credible? So it has nothing to do with that, because we don't have any evidence of that. Just the return of their verdict doesn't mean, oh, well, you know, it means that they're not credible. It just means that something went on in there that we don't know about. And I mean, if the jury's confused, then there needs to be clarification on that. Trying.
You know what, Mr. Branch, I do actually really do share your concern on this. And I have seen this a number of times during my, it's not unheard of, unfortunately.
I know.
That was probably a bad choice of phraseology, but I've always been in the position that I'm going to respect the jury's verdict. The case yesterday, to me, is even more difficult in this case, because it was a situation where there was property damage and personal injuries. There was no controverting evidence as to the property damage, and it was a 50-50 deal, and they didn't award the property damage. And that, to me, is even more difficult than this one. Anyway, that being said, if I start doing this on every case, I got to be consistent. I don't like it, but I'm gonna go ahead and deny the motion for new trial. But I will say on this other case, I'm more inclined to do it just because there was no evidence conflicting the it was property damage. I mean, it was they had an affidavit that showed that there was, anyway. That's not this case, so you don't have to worry about it. And you submitted an order for me, Ms. Monroe?
I have a final judgment that's on file with the court. Is that
Well, I need
sufficient?
an order denying the motion for new trial. So
we'll do that right now.
If you could create that, just a very basic, plain vanilla, denies the motion for new trial. Don't put a bunch of extra verbiage in there. I've seen that before. Not usually car wreck cases. Commercial litigators like to do that a lot.
Yeah.
Make sure that it says at the beginning that this was heard on March 25th, 2022. Make sure you share it with Ms. French, and then email, go ahead and email my court coordinator and e-file it as well.
Okay. Ms. Judge, are you going to sign the final judgment, or do I need to file a motion?
Did I already sign it?
If you did it yesterday, and I haven't looked.
All right, I apologize. I usually would have signed that. Let me look that up real quick. You may be right. I have a big.
No, and that's fine, Your Honor. I'm not in the registry, so.
I want to get it signed. I thought this was a motion for new trial, which you wouldn't do until after the judgment, wasn't this a motion for new trial?
Yeah, it was.
It was.
You don't usually file those until after the judgment is signed.
Oh, I didn't.
Might have gotten a little excited. I don't know.
Oh, and believe me, Amanda.
You're just so eager.
Yeah, call me later, Amanda. You and I will talk. You and I will talk about how eager I was. Okay.
Let's see.
I will remove that phrase from my repertoire. I've heard of. It came out of my mouth, and after it did, I was like, I can't take it back. It's out there.
It's all right.
I'm looking for, okay, there it is. I will go ahead and print that out right now. You're right, I have not signed it. I apologize for that. My computer is just not cooperating with me today. Okay. I'm printing it out right now, and let me just see if you actually did. Thank you. You know what? I may be able to just print her one granting it and just cross out granting, and let me see how it looks. All right, well, guys, thank you so much. And you guys be safe, okay? It was good seeing you. Have a great weekend.
Absolutely. Thank you, Judge.
you.
And Amanda, do call me this afternoon, okay? I've got a meeting though, but call me, okay?
Okay, sounds good.
All right, see you later, guys.
Bye.
So are both sides here on this motion to appoint receiver is,
Mr. Grant is on his way from next week. We got our signals crossed. We got a Zoom link yesterday. We're thinking, okay, it's gonna be Zoom. And then we called this morning. They said that's it. He's hustling from Mansfield. And I'm waiting for my client to show.
so the issue, I apologize. We have